Good afternoon. My name is Hashma Hashir, and in this presentation, I will be analyzing a legal dispute between State Aramaica and the State of Batona, arising from the unilateral suspension of a bilateral treaty concerning a joint dam project. A treaty, as defined under Article 21A of the Vienna Convention on the Law of Treaties, is an international agreement concluded between the states in a written form and governed by international law. This definition clarifies the legal nature of the dam agreement at the center of this dispute. I will be assessing the legality of the Aramaica suspension, evaluate Batona's defenses, and examine how key principles of treaty law, including pacta sunt servanda, material breach, and rebus sic stantibus and jus cogens, interact under the VCLT. I will also be briefing about the articles 54, 61, 64 where it's relevant. The first principle I'm going to explain is pacta sunt servanda, Article 26 VCLT. So Article 26 states that every treaty in force is binding upon the parties to it and must be performed by them in good faith. This principle, known as pacta sunt servanda, forms the backbone of international treaty law. It ensures predictability, legal stability, and mutual trust. However, its application is not absolute. As the ICJ noted in the North Sea Continental Shelf Case 1969, consent is foundational. A treaty binds only those states that have genuinely agreed to it. In the Nambia Advisory Opinion 1971, the ICJ effectively acknowledged that fundamental principles like self-determination can override treaty obligations. Though not labeled as jus cogens, this case shows that higher norms can influence pacta's limits. The takeaway is that pacta is the rule, but subject to exceptions like material breach, fundamental change, and preemptory norms. The second principle is material breach. Under Article 60 of the Vienna Convention on the Law of Treaties, this provision allows a state to suspend or terminate a treaty if the other party commits a material breach. Under Article 63b, a material breach is defined as a violation of a provision that is essential to the accomplishment of the treaty's object and purpose. But what does essential really mean? This is where interpretation becomes complicated. The ICJ in the Gabsikova Nagamaras project case in 1997 acknowledged that environmental protection could be an integral part of a treaty's object and purpose, especially in treaties concerning sustainable development. This opens up doors for environmental breaches to potentially qualify as material under Article 60. In the Rainbow Warrior Arbitration 1990, the tribunal stressed that a material breach must go to the very essence of the treaty, not just any violation will suffice. Similarly, in the United States diplomatic and consular staff in Tehran hostages case, the ICJ cautioned against unilateral suspensions. It emphasized the importance of judicial oversight, warning that unilateral acts, especially by more powerful states, could undermine treaty stability. So what is the issue? The term essential is vague. What one state sees as an essential breach, another might view as minor or politically motivated. Without clear legal standards or judicial review, there's a serious risk that Article 60 could be abused, particularly by powerful states using it as a pretext to escape treaty obligations. That is why material breach needs a careful interpretation within a structured legal framework, not just a political discretion. The third principle is Article 62. Article 62 permits withdrawal if there has been a fundamental unforeseen change of circumstances that radically alters the treaty obligations. However, two exceptions apply. It cannot apply to boundary treaties and it cannot be invoked if the change was caused by the party relying on it. In Fisheries Jurisdiction 1974 and Frontier Dispute 1986, the ICJ made it clear Article 62 is rarely accepted. Courts fear it would destabilize treaty law, but modern challenges challenges such as climate change or pandemics have renewed. Many scholars call for more flexible interpretation. In Iron Rhine, the tribunal favored reading environmental obligations into treaties, pushing towards adaptation rather than withdrawal. The fourth principle is jus cogens. Article 53 VCLT. Article 53 states that a treaty is void if, at the time of its conclusion, it conflicts with a peremptory norm of general international law. These non-derogable norms, like the prohibitions on genocide and torture, reflect universal values. In Forensica and reservations to the Genocide Convention 1951, the status of such norms was reinforced. Bothona argues that access to clean water has reached this level. The UNGA Resolution 64292-2010 and subsequent declarations support this. However, there is no binding ICJ judgment yet classifying clean water as jus cogens, making this claim aspirational, not legally confirmed. Supplementary principles. Article 54 termination by consent, not applicable here since Aramco acted unilaterally. Article 61 impossibility of performance may arise if the dam or river system is irreparably damaged. Article 64 new jus cogens norms. If clean water becomes jus cogens in the future, any conflicting treaty would be void. Now I will be talking on issue 1, which is Aramco's suspension unlawful? Aramco claims Bothona's failure to follow environmental safeguards constitutes a material breach. These safeguards are not peripheral, they are central to the dam's purpose, ensuring substantiability and public health. In Gumsikoor Nagimaras, the ICJ stressed that environmental duties are not marginal, they go to the treaty's heart. But there are two hurdles. Aramco must prove the breach is substantial and not just technical. Aramco must act in good faith, not as retaliation. As explained earlier, international jurisprudence, including the Rainbow Warrior and hostages case, affirms that only breaches going to the core purpose justify suspension, and that unilateral action must meet the test of good faith and legal process. Aramco could strengthen its position by referring the matter to an independent dispute forum, ICJ, or arbitration to avoid the perception of self-interest. Aramco has a legal plausible claim, but its success depends on whether the breach was truly material and whether a proper process was followed. The second issue is, can Bothona invoke Rebel 6 Tantibus Article 62? Bothona argues that climate change is a radical, unforeseen change that invalidates the environmental terms of the treaty. Since this is a bilateral treaty, invoking Article 62 would result in the entire treaty collapsing, not just amending the clause. The ICJ and arbitral tribunals are generally hesitant to accept Rebus 6 Tantibus in bilateral contexts because of this severe consequence. However, climate change, though evolving, is now a foreseeable risk. In fisheries jurisdiction, the ICJ accepted the theory but refused to apply it. The ICJ acknowledged that changing circumstances could, in theory, affect treaty obligations and early towards the idea behind Rebus 6 Tantibus. However, the court rejected Iceland's argument that changes in fishing practices, fish stocks, or ecological concerns were enough to unilaterally terminate or modify existing agreements. The ICJ ruled that Iceland could not unilaterally extend its exclusive fishing zone to 50 neutral miles because the parties were still bound by the prior agreements and obligations under international law. In Iron Rhine case, the tribunal held that the treaty between Belgium and the Netherlands remained valid despite environmental and technological changes. It emphasized that states must interpret treaty obligations in line with evolving international environmental law. Rather than allowing termination, the tribunal required both states to adapt their treaty obligations, balancing Belgium's right to railway access with modern environmental protection standards in the Netherlands. Botona could have requested treaty renegotiation or scientific review clauses but did not. That weakens its claim. So, to conclude, the threshold under Article 62 is extremely high. Botona's defense is conceptually relevant but likely fails legally. Then the third issue is if the clean water is jus cogens. Botona says that the dam violates a peremptory norm, access to clean water. We can see increasingly global support for recognizing environmental rights. The UN General Assembly Resolution 64292 and the Human Rights Council's Resolution 48/13 in 2021 are key milestones. Louis Coetzee also explores this evolving recognition in his contribution to Knox and Peja's edited volume on the human right to a healthy environment. According to Article 64 of the VCLT, if a new peremptory norm of general international law emerges, any existing treaty conflicting with that norm becomes void and terminates. However, these are soft law. The ICJ has not declared clean water as jus cogens norm. In Kapsikawa Nagamas, the ICJ acknowledged environmental importance but stopped short of elevating it to peremptory status. In Pulp Miles 2010, the ICJ addressed concerns about the protection of the river Uruguay's water quality. Despite Argentina's serious allegations about environmental degradation and risks to water resources, the court relied on treaty obligations and found no breach of substantive duties. Importantly, the ICJ did not elevate environmental protection or access to clean water to jus cogens status, reinforcing that while these concerns are growing in importance, they remain outside the scope of Article 53 VCLT for now. Jus cogens may evolve, but until there's a universal recognition, its use as a defense remains speculative. So to conclude, Botona's argument is morally powerful but legally premature. Now I will be talking about the recommendations. For Aramika, the recommendation is to maintain suspension only if the breach is judicially validated, otherwise use Article 33 of the UN Charter to seek peaceful settlement or submit to ICJ jurisdiction. For Botona, drop the weak Article 62 and jus cogens claims. Instead, request treaty renegotiation to modernize environmental clauses. Propose a climate adaptation mechanism or independent environmental review. For the international community, urge the International Law Commission to codify emerging environmental peremptory norms, promote inclusive of review clauses in all transboundary treaties to handle climate evolution without triggering exit disputes. To conclude, the VCLT balances legal stability when necessary, flexibility while pacta sunt servanda ensures trust in treaties. Articles 60, 62, and 53 offer escape routes in limited high-threshold situations. In this case, Aramika suspension under Article 60 is legally arguable but must follow due process and judicial oversight. Botona's defense under Article 62 and jus cogens reflect emerging values but do not yet meet legal standards. As global crises reshape our world, international law must remain principled yet adaptable. The future lies not in breaking treaties but in building resilient and just ones. Thank you.